Um, Good morning, everyone. I hope we're all having an amazing weekend. My name is Amina Suleiman, and I am the program's legal to our house. I will be a step in ensuring that legal reform on the tables will also translate into tangible benefits in our communities. Our session for today will focus on the Kano State Administration of Criminal Justice Law, ACJL 2019. The ACJL is a landmark legislation, but its full impact can only be realized when people actually understand and engage with the law. So today I am honored to introduce two distinguished speakers who will take us through the topic, the discussion for today. Our first speaker is none other than Your Worship Salma Ahmad Dambapa. Your Worship is a seasoned legal professional, a retired chief magistrate, and the current chairperson of the International Federation of Women Lawyers Kano branch. With over 35 years in the Kano State Judiciary, she has dedicated her career to advancing justice, protecting the vulnerable, and strengthening community access to justice. You are welcome, Your Worship.
Thank you.
And our
Can you
second
hear me?
speaker, yes, I can, Your Worship.
Okay.
And our second speaker for today is Barrister Jamila Inua Saad. Barrister Jamila is a dedicated legal professional with extensive experience in providing legal aid services and promoting access to justice. As a senior legal aid officer, she is committed to ensuring fair legal representation for all, especially the underserved. She is an associate chartered arbitrator. She brings expertise in ADR, fostering amicable settlements and reducing litigation burdens. In her role as treasurer of the Nigerian Institute of Chartered Arbitrators, Kano State Chapter, she contributes to the institute's growth and governance. You're welcome, Barrister. We are excited to hear you speak today. Barrister, can you hear me? So we'll be moving on to the second item on the agenda for today, where I will take us through an overview and introduction of the Justice for All project. The Justice for All project, before we discuss the project itself, I would like to give us a background of IWA and the work we do. So Isawali Empowerment Initiative is a women-led non-governmental organization that was founded in 2009. At iWay, we carry out projects that advance gender justice. We do this by employing legal empowerment as a cross-cutting approach across all our thematic areas, which runs across protection and justice, livelihood support, and quality education. In furtherance of this, we propose the Justice for All to promoting community awareness of the Kano State Administration of Criminal Justice Law project. Now, despite the enactment of the Kano ACJL to enhance justice delivery and protect human rights, its intended impact is significantly limited due to the lack of knowledge, awareness, particularly among vulnerable women, girls, and marginalized communities across Kano. At IWay, we carried out baseline evaluation, which showed that Kano has established key compliance mechanisms and seen institutional improvements particularly operational gaps, particularly within policing agencies with regards to the Kano State ACJL. Now, awareness level amongst justice actors. By justice actors, I'm referring to the police, legal practitioners, and the likes. So awareness in this area is quite moderate, actually. And then within civil society organizations, we'll say awareness has really improved due to a project that has been supported by RoLAC, where the KCSF has trained approximately 450 CSO representatives and 75 CSOs on ACJL provisions and advocacy strategies on the law. But now we are coming down to public and community awareness. With regards to community awareness, especially amongst marginalized communities, awareness is generally low, particularly in rural areas and among women. Now, to address this, broader sensitization initiatives must be employed. Basically, in summary, this evaluation showed that the Kano State has made notable strides in implementing the ACJL, but nonetheless, significant challenges persist, particularly with low awareness among community members, I would say. Now, this lack of knowledge leaves individuals susceptible to abuse, discrimination, and wrongful detention that has hindered their ability to exercise their legal rights and participate effectively in the justice system. The Justice for All 2 project is a 12-month project that has been currently being implemented by Isawali Empowerment Initiative in partnership with International IDEA with support from RoLAC II program. It's built upon a successful 1-month project funded by RoLAC in November 2024. To enhance this project primarily seeks to enhance awareness on the application of the Kano State Administration of Criminal Justice Law, particularly among vulnerable girls, women, girls, and youth, as I have stated earlier on. We intend to employ a multifaceted approach with regards to implementing this project. We intend to develop accessible communication materials, particularly in Hausa and English language, utilize various media platforms for outreach, conduct community sensitization activities, engage with stakeholders, and provide direct legal aid services through community-based law clinics, which are aimed to enhance legal literacy, demand for justice services, and ultimately contribute to a more equitable justice system in Kano State. Now, the 3 broad objectives of this project is to first, develop gender-inclusive communication materials, to engage with local communities through social media like what we are doing presently, traditional media, e-media, through radio and TV, and then through community events. We also intend to provide women and girls accessible community-based legal aid services, referral, and information on available legal remedies. For this project, we're working with 6 communities in Kano State. We're working with Wudil local government, working in Wudil local government area, Bichi local government, Rano, Ungogo, Dawakin Tofa, and Nasarawa LGA of Kano State. The project duration, as I've earlier stated, is 12 months, and we intend to meet at least 1,000 beneficiaries through our community sensitization events, at least 500 beneficiaries through our symposium event, which will be coming on later on this year, and then 10,000 beneficiaries through social media engagements like this. 50 stakeholders will be engaged through advocacy and stakeholder consultative meetings, and then 10,000 beneficiaries through our call-in live programs, which will also be coming up later on this year. So with this, I believe we have a general idea of what the project is about and our deliverables and what we intend to achieve generally on the Justice for All project. Thank you. So we will now be moving on to our next item, which brings us to our main discussion for today. The topic for today is understanding the Kano ACJL, an overview and introduction of the project and the key innovations of the Kano State ACJL. So, in order to get an idea about the key innovations, we have invited a renowned speaker, someone who has experience in who has experience on the bench and has had interface with this law on several occasions to handle this topic. Your Worship, Salma Ahmad Dambapa will be taking us through an overview of the Kano State ACJL. Thank you. Over to you, Your
Is this not too much for me? Honestly, this is too big. This is overwhelming. Interesting. Alhamdulillah. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuhu once again. Administration of Criminal Justice Law is not a new law, and it is not a law that supersedes the existing laws in the Nigerian context. And it is being implemented in Kano in 2019 officially, but it was in existence from 2015 because then it was on testing level. That is why we have two laws in Kano reading Administration of Criminal Justice. One, Administration of Criminal Justice Act and Administration of Criminal Justice Law, but they are one and the same. And we have moved to have a Hausa version of it. So I wonder, this our conversation, whether it is going to be next time to be in Hausa language because of the coverage of the areas where the project is taking place. I know the predominant language there is Hausa, and my humble self, Hausa language is my first language and English to be my third language. So next time, possibly it should be in Hausa for much participation and better understanding. The second thing, the beauty of it is about its expected outcome. That is overstretching the need to include family members like biological relatives, mother, father, brother, and any other family member to stand as a surety to a defendant, a person that is being alleged of a crime, including capital offense, because that will give room for the family members to understand the context and the nature of the charges or allegation leveled against their family member. And that will give them an opportunity to ensure that he's been punctual to court or been produced from custody where applicable, and that he is clearly in the picture of what the whole proceedings entails. Same goes to a wife. She can stand as a surety to her husband, except if she is a co-alleged person. But if that is not the case, she can stand as a surety to her husband, and a mother can stand as surety to her child or a grown-up person. And another beauty of this law is that the bail conditions too are a little bit relaxed. That is why most of the lawyers complain that administration of criminal justice law is defendant friendly, because it relaxes the bail conditions where the court makes it stringent or where it is vague, because there would be a circumstance where the court will apply strict conditions for bail. And ACJL is promoting not to be too harsh, irrespective of the nature of the crime, so that a defendant will now be set free unless and until such a person cannot satisfy the set out conditions. Another beauty of the ACJL is that it changes the name of the defendant from accused person to a defendant. Initially, in the criminal context, wherever a person is being prosecuted with a charge on contents of the FIR, he's been referred to as an accused person. But coming with the ACJL provision and its full implementation in Kano, records are now clear that it is no longer an accused person, but rather a defendant, because he is being alleged of committing a crime. So it is only when he is being proved, or the case is being proven beyond reasonable doubt, and upon conviction, that he's going to be called a different name, not a defendant, again, a convict. And that shows he has passed through the process. So that's another beauty of it. Then another beauty of the administration of criminal justice law is on the bail bond. Initially, bail bond is too generic in such a way that it is required almost in all criminal cases, be it in financial value, be it with a property or any other thing that can be quantified, certified by the court. But with the implementation of the administration of criminal justice law, bail bond is now prescribed per quantum, though it is controversial, highly controversial, because the practicing lawyers opines that it is in contradiction with the fundamental human rights of presumption of innocence. But yet, it is still part of the provision of the administration of criminal justice law. And sometimes we have to ignore that and look at the amount involved in that criminal case as per the contents of the FIR, the nature of the charge, which sometimes it is more related to financial crimes, EFCC cases, and cases of breach of trust, cheating, and the like. And one will see the volume of amount of the fund involved is running into millions, billions, and to request for a bail bond in that regard. So it depends on who the lawyer is and how professional he wants to be. But that's part of the beauty of the administration of criminal justice law. And if I can still recall others along the line, I can add more, inshallah. We hope it is okay.
Thank you so much, Your Worship. So before I move on to the next speaker, I have some questions, or should I say, like clarifications I want you to make. For instance, we have
Okay.
Section 30 of the ACJL that provides for arrest in lieu, prohibition on
Mm.
arrest in lieu. So I'd like you to give us more clarification on this.
Alhamdulillah. In the criminal law, arrest can be effected immediately a complaint is being lodged. And an arrest can be effected by any other person that is within the vicinity of that crime that is taking place at that particular time. However, with the implementation of the criminal justice law, arrest in lieu is that kind of arrest that a person can be arrested irrespective of a crime that is yet to be accomplished, but it is being prepared, and in fact, it is in the pipeline of execution. That is where there are several offenders, and it's like a gang crime. So each and every person that is being mentioned should be arrested alongside the principal offender. So arrest in lieu will take place where the offense is being noted that yes, that offense within the probability of that strategic location, it is going to take place immediately, so that societal unrest cannot be given room to be escalated, and the suspect or defendant cannot be given room to abscond the initial arrest upon execution of their plan, criminal activity plan. Likewise, where it is something that relates to um, governance or leadership, and it relates to financial embezzlement, mismanagement of funds, and related matters too. In lieu can be effected so that such a designated officer can be arrested to ensure that such alleged crime do not take place as per their plan. But it has to be certified that yes, a crime is in the pipeline to take place. And such a crime is going to cause more loss than when it is not being addressed immediately. That's the only difference, because one needs to be arrested immediately or upon complaint. But in lieu is that full knowledge of the plan is on ground. They are just waiting for the time to click on just to execute it. Thank you.
Thank you, Your Worship. So I'm still on you. So I want to know, I just want to get clarification on some issues that I know some of our listeners have on in their minds. So in a case where a person an arrest warrant is written against a particular person and the police are there trying to take the person into custody, but the person is not available and then they decide to arrest someone else in his place. What do you have to say about this and how the ACJL is protecting them from this particularly?
Taking another person in place of an alleged perpetrator or defendant is key to extinguishing a societal unrest and addressing a criminal activity taking place. Take example of defilement or procuration of a minor, which is too common in our area in Kano.
I think her network is giving her some challenge. So before she comes back on, I would like us, since we don't have much time left, Barista, I would like to move on to you. Then we can go back to her and get clarification on some other issues. So moving on to Barista Jamila Inua Saad, who is going to take us through the need to create awareness on the ACJL. So Barista, you have so much experience. You've been serving the underprivileged. You've been working with them for several years. So do you think it's even important? Why should we even create awareness on the Kano State ACJL? Thank you.
Assalamu alaikum wa rahmatullah. Good afternoon,
Vale.
everyone. I am Jamila Sa'al from Legal Aid Council of Nigeria, Kano office. We are about to talk on a very important thing, which is your right, your safety, and how justice should work for you. Like you said, I have been working with the less privileged, been with Legal Aid Council. Okay, looking at the administration of criminal justice law on its own, it was enacted to modernize and harmonize criminal procedure, enhancing protection of human rights, promoting transparency and efficiency in the criminal justice system. The impact of the law just being in the books is not meant for itself. It is to be applied, to be enforced. So if the stakeholders are not aware of the law, it cannot be fully realized. The stakeholders, that's the law enforcement agencies, the judiciary, lawyers, civil society organizations, and the general public all need to be aware of its provisions for it to have its full potentials. The ACJL is not just to protect the accused, or rather the defendants, it is also to protect you and me, ordinary citizens, from injustice. It is your right. When you know your right, you can speak up about it. When the police and the courts know their duties, they will act within the bound of the law. For instance, I took some of the provisions of the Act to show why awareness is key. Let's take the first one, issue of arrest. If citizens or subjects know that if they submit to a lawful arrest without hesitation, they are not, the police officer will not use any force or restraints on them. That is the provision of the ACJL. When you admit to, you submit to an arrest, either by words or by your action, like, okay, you are here to arrest me, let's go. In that case, you are not to be restrained unnecessarily. So knowing this will help to prevent unnecessary use of force and violation of human rights, particularly right to dignity of person. Because mostly when arresting people, they will be handcuffed, they will, like, lots of force will be used. So if you know that, you will prevent all these unnecessary dramas. And then ban unnecessary restraints. We have right to be informed of why you are arrested. This will help you to challenge situations where you are unlawfully arrested, because the law still prohibits arrest in cases of in civil cases that do not have element of crime. Pure breach of contract will not warrant the police to arrest a person. So if you know that, it will help you to challenge unlawful arrest. Like on the issue of arrest in proxy, regardless of situation, you painted a scenario where a warrant is being issued in the name of, let's say, Jamila. Regardless, no matter how big the crime I've committed, it cannot be executed against my sister, my mother, my father, or any other person, on the pretense that if they arrest that person who is related to me, perhaps I will submit myself. So the law has clearly prohibited arrest in lieu of another person. It is only the person given whose name is mentioned on that warrant that can be arrested. And then another importance of awareness of the provisions of the ACJL is it will help the citizens to avoid self-incrimination. This is in a situation whereby you know you have a right to keep quiet or to remain silent until after consultation with either your defense counsel or any other person of your choice. This will help you to prevent saying things that will be used against you in the court of law. And then it's only when you are aware of these provisions that you will keep quiet and then wait until after consultation with your counsel before you make any statement. Similarly, being aware of the provisions of the ACJL will help you to know that for indigent persons, marginalized groups, less privileged, you have a right to free legal services when you don't have what it takes to enjoy the services of private legal practitioner. So when you are accused of committing a crime, you can engage in services, you can go to legal aid counsel, engage a lawyer who will defend you to the best of his ability. Also, the arrest in lieu knowledge of not being arrested in lieu can help you curb the excesses of the police. If you know that the police can only arrest the person who has committed the crime, the fact that you are related to that person will now warrant the police to arrest you in lieu. There's also a requirement of monthly inspection of detention facilities, not correctional centers, detention facilities by the magistrates. This will ensure compliance with the requirement of law in detaining suspects, because some will be detained unnecessarily over the period of time permitted by law, or it's at least illegal detentions can easily be noticed if a magistrate will visit detention centers every month. So no person would be detained in any facility for more than a month without him coming to a record. Also, the ability of the issue of freezing accounts in cases of financial crimes. If you know as a citizen that no bank has the right to freeze your accounts without court order, so that means it will help you to even challenge the court order, because that order was given expertise to freeze your account. Knowing that you have a right to go and set aside the order if you feel it was unjustly given. It's only the knowledge of the content of the ACJL that will help you to do that. We have lots of them. Issue of timeline within which cases, for instance, at the magistrate court will begin and when it should end. Cases at the magistrate court must begin within 30 days from the day a complaint has been lodged or FIR was filed. And then it must be concluded within 90 days from the date of the complaint to the date of judgment. So this will help you report cases of undue delay and what to do next. We have cases of strict time limit for remand proceeding. You will find suspects or defendants being detained for over 2 years and only to appear before a magistrate court for further mention and then adjourn for another further mention. Remand proceeding has a time limit, 21, 14, 14, 14. So after the expiration of this period, if you are abreast with the content of this law, you know that you have a right to go somewhere else. It's either you are the AG or the controller of prison is given should show cause why the defendant should not be released conditionally or unconditionally. And then we have issues of taking of plea. This is one important section of the ACJL, I think, with the public needs to be aware of. There are instances where you have public interest cases, for instance, cases of murder, like the one that happened, the case of Hanifa, and other serious cases that happened of murder. When taken to court, this is a case that, to your own understanding, to a lay person, he can say the person has admitted guilt, even narrated how he committed the offense, and then going to court, it is now that a plea of not guilty was recorded for him. How? So to them, it will outreach justice. So knowing the content of the ACJL, you know that in capital cases, even where a plea of guilty is made by the defendant, a plea of not guilty will be recorded, and it will be on the prosecution to prove their case. So when you know that that issue of mistrust and misunderstanding among the public will be done away with. These are some of the examples of the content that will help you understand better, and then will win the trust of the public in the justice system. So in all, I can say we can have like several reasons or importance of public awareness of the ACJL. First is protection of fundamental rights. Without public awareness, individuals may continue to suffer rights violations simply because they are unaware of these legal safeguards. Two, we have accountability and transparency of law enforcement. Awareness among the public and enforcement agencies ensure these safeguards are applied consistently, holding authorities accountable when they are breached. And then we have the issue of the importance of efficiency and timeliness in criminal proceeding. When lawyers, defendants, and even the courts are reminded of the deadlines of criminal proceedings, they will take action, and then you know what to do when delay occurs, where next to go. The fourth thing is we have fair and accessible bail processes. Educating communities on the provisions of will reduce exploitation and ensure defendants are not held simply because they cannot meet excessive or even unlawful bail conditions. Recently, I had a case that I went to court, and part of the condition was 2 ward heads must stand as sureties for the child. But going back to the ward heads, they said the Emirate Council gave an order banning them from standing as sureties. So you see that condition becomes more of impossible. So if you don't know that you have a right to go to court and reapply for alteration of that condition, and bail conditions should not be excessive, the court cannot ask you to do something that is not possible. So when you know that you have a right, you can easily go back and get remedies. We have modernization of criminal procedure. Just like in under the ACJL, it's not all cases that must go into full-blown trial. You have cases of plea bargain. Though it's not applicable in serious cases that relate to either sexual offenses, terrorism, alcohol, and other things. But other cases, especially financial cases, you can plea bargain on them. And this plea again ensures that the victim's right or his view is taken into consideration. We have empowering citizens to seek legal remedies. Public awareness ensures individuals know how and when to invoke these rights, who to approach. Is it the courts, the AG, Attorney General, or even legal aid providers? So it's only when you know of the content that you'll be able to leverage on this. Lastly, promoting justice sector reform goals. Continuous sensitization campaigns can create a culture of compliance among law enforcement officers and encourage citizens to cooperate with lawful judicial processes. They will not give you unnecessary troubles when you want to do something that they know you are following the procedure of the law. So I think finally I can say awareness of the ACJL is not just a matter of legal literacy. It is a key driver in ensuring justice, fairness, and protection of human rights in Kano State. If law enforcement officers understand their limits of power, courts apply their provisions faithfully, and citizens know their rights and obligations, the law will achieve its intended purpose, which is efficient, fair, and humane criminal justice system. So I think public enlightenment campaigns, targeted training for justice sector actors, and community outreach programs are essential to bring ACJL not just on paper, but to practice. Thank you.
Thank you so much, Barista. That was such an insightful discussion. You did so well. So for me, I would say two things actually stood out. You spoke about so many things and you brought out so many issues that are very relevant. First, you spoke about how knowledge of the ACJ will reduce mistrust of the justice system, right? So this awareness is important. It will also help the justice actors to do their job. It makes their job easier because now the populace will trust them and allow them to do their work the way it should be done. And then secondly, you spoke about how knowledge on the ACJ will help bridge the access to justice because now people know where to go, what to do when a particular issue arises around it. So thank you so much. I have some questions that I would like you to, give us more clarification on. So we know these rights, like for instance, the case of arrest in lieu, the prohibition of double jeopardy, and all of that are provided also under the Constitution of the Federal Republic of Nigeria. Now, some people have the opinion that since it's already there, there's no need for us to have it in the Kano State ACJL. While some insist that emphasis is important to bring them forward because, okay, they are fundamental rights that are non-negotiable. Everybody should enjoy them. So what is your opinion on this?
I think that it's as important we have it in the ACJL because the Constitution is a law that governs all other laws of the land must be in line with the Constitution. So, like you said, for emphasis, and then for what would I say? Like ACJL is more of a procedural law, while the Constitution is a substantive law. It's provide what, then how to do it. If we leave it only to the Constitution saying you have a right not to dignity of person, it does not say these are the ways that these rights can be breached. So if you come back to the ACJL, it's saying it's a procedural law that provides how criminal cases, both as magistrate courts, high courts, or Sharia courts within Kano State, should be carried out. So it gives you detailed explanation on instances where such rights can be breached, and then what to do after the breach. Because the Constitution only said, okay, you have a right to this, and then it's listed courts and said the courts have jurisdiction on this. Then how can you bring the two together? I think it's ACJL that will tell you this is how you go about it. If you want to initiate this, come through this, do that, do that. For instance, in cases of financial crime, we say it's only on expertise order that bank can freeze your account. Then after freezing your account and you feel it's against your rights, how will you enforce the right? Then that same ACJL is telling you, okay, now go on notice to set aside the order. So I think they are complementary. It's not like one is saying one thing and the other is saying another. It's complementing and adding power to each of them. So mostly you see when you are writing your brief on a case or you are making submission before a court, you can first bring the provision of the Constitution, that the Constitution guarantees this right, this right. And then by the ACJL, because you are coming down to the courts now, ACJL, for instance, the Constitution is not applicable. Powers of the courts, magistrate court will not be seen in the Constitution. It gives the state the power to create magistrate courts. But if you come to the ACJL, it has specifically mentioned Sharia courts, high courts, and magistrate courts. So there is no way the courts will have no excuse to say, no, this is a general provision that might not apply to me. No, we have a specific provision for you. So I think it's a good addition.
Thank you so much. So one last question. In your years of experience, I know you've worked with indigent persons since you provide free legal aid services to indigent persons. So can you tell us, like, what's the difference? Have you when you meet clients who know their rights and those who don't know, what difference do you see they exhibit in generally in their mannerisms and how they support you in carrying out your job?
Like, it goes a long way, and it makes us to be on our feet. Like, not just you as a lawyer, even the courts, when you go to courts, a lawyer that knows what he is doing and the one that is not up and doing about where to find his laws, you know, the response he gets from the court vary. So where a person comes to you that knows his rights, you won't take his case as a joke. You will be up and doing to ensure that you are following due procedure. Because if you do anything differently, they will tell you, but barrister, I was told that I read somewhere that this is how it should be done. Why are you doing it? So you should have an answer to give. It will be you yourself. You don't need anybody to tell you how it feels when someone is challenging you and you know fully he is right and you are wrong. So definitely when you handle cases of people that are aware and those that are not, it's different. And then it makes you to give your best and ensure that you're following due procedure. Likewise, when you have, I had a case of a child that had accident in a company and his arm was amputated. So the other lawyer the company lawyer tried to explain to them that they have to go to NSITF and then payments will be given monthly for at least 55 years or thereabouts. So they saw it as, no, you should just give us a bulk sum and then say you've settled us. So I had to explain to them, this is not the way it is done. The law requires that you do this, you do this, you do that. So if a person knows this, it has saved you the stress of explaining to them, this is how you do it, this is how you do it. And it will keep you on your toes to do the right thing. And it will also push you to act the court. Because sometimes we'll be reluctant, knowing fully that, for instance, this issue of remand, at the lower courts, some courts are reluctant to release a defendant, even after staying for at least 2 years on remand proceeding. Knowing fully this is the provision of the law, it only gave 21, 14, 14, 14, 14. But the person, which is not up to, I think, not up to more than 3 months, but you see a person staying under remand proceeding for over 2 years, and the magistrate are reluctant to do that, to release him on bail. So I feel if you have an informed client, and then the lawyer is also willing to do his own part, the magistrate will have no option. It's either she releases him or you go up and then get an order that will release him on bail. So everyone in the chain has to be up and doing. When you have an informed client, it will help the lawyer, both parties, both lawyers, the prosecution, the defense, and also the court to do the right thing.
Thank you so much, Barista. That was thank you. That was so much. Like we really learned a lot. So I'm glad that your worship is back on now. I have a question I would like to ask you, if you can give us clarity on that. So you wear two hats. Yes, you were on the bench and you're also the chairperson of International Federation of Women Lawyers. So as a CSO person, I would like to know from your interactions with members of the community and of course clients who also come to you, does awareness actually empower them when they are aware of these laws and policies that have been put in place? Does it empower them, or it's just a fruitless, should I say, endeavor?
Alhamdulillah. Let me take one step backward first to clear this section 30, that is arrest in lieu. The ACJL is categoric on the arrest in lieu, particularly prohibiting arrest in civil matters. That means it is not saying that arrest of a shorty, arrest of a family member in case of a criminal complaint should be prohibited or is thereby prohibited. It is in civil matters. So we need to be too clear about it, because civil matters, we know they are entirely different from criminal matters. And civil matters usually are based on contract terms and conditions, which differs from one contract to another. Meanwhile, in criminal activities, the safety of the society and the community per se is always paramount. That is why a shorty can be arrested so that the actual initial perpetrator or defendant should present himself, or the family members to present him. Yes, that's cleared. But for CSOs and any other stakeholder, information is key. Wherever there is no adequate information, then awareness is less. And so people will not be aware of what is happening. So for CSOs not to even engage in massive awareness creation in relation to provisions and effective implementation of any law that is in existence and in practice, honestly, is not being fair to each and every one of us as the CSO executive members, and it extends to the larger society. Because CSO as a registered organization is deemed as a representative and mouthpiece of the larger society. So if information is not being disseminated accordingly, then the result or expected outcome will not be coming as expected, or even it is going to be not even clear about it. So information dissemination and sharing is key. Only that whenever we are sharing any information with regards to the provisions of the law, it should be disseminated in that professional context. If you know that you are not clear about the provision of the section, you need to seek knowledge. That is why in the legal profession, the Young Lawyers Forum emphasizes on 3 key steps: learning, relearning, and unlearning. You continue to acquire more knowledge and experience so that you excel and become an expert in what you are doing. You relearn because you have to readjust, readopt, and reapply certain specific provisions of the law in line with the certain peculiarities. And you have to unlearn where that particular provision is no longer relevant or in existence, or it is not needed in that particular conversation or adjudication or whatever it is that relates to dispensation of justice. Yes.
Thank you so much, Your Worship. Um, Barista, I'll be going back to you. If you have any additions, any additional information you feel you would like to share with our listeners, I'll hand over the mic to you.
Okay, the only thing I will need to add is presence of legal aid council in Kano, which is for vulnerable, less privileged, or marginalized group. It is located at the office is at first floor Gida Murtala. Whenever you feel you are suspected of to have committed an offense, or even in civil cases where you have rights either are breached or about to, you can go to the office. The admin officer is there, and he can take your brief, and the head state coordinator will go through. If it's one that is within the powers of the legal aid, a lawyer will be assigned to you to handle the case freely. Thank you.
Thank you so much. Thank you for that information. It was our listeners, I'm sure, are very glad to hear to get that. Your worship, do you have any concluding statement you'd
In
like to
that
make?
case, we can share our address too because we run a legal clinic and Jamila is part of the members of the legal clinic because the legal clinic is part of our legal professional services. FIDA is a pro bono legal organization and we are not gender specific and we serve the whole community or society, be it from the professional group, the commercial sector, wherever, whenever. And at every point in time, we do have services within that clinic. We do have alternative dispute resolution. We do have counseling, psychosocial counseling or therapy. And we have an existing standing litigation committee where we can follow that case from police station to state headquarters up to the courtroom, inshallah. Our office is located at number 43 Lawan Dambazau Street, Inuwa Jama'ar Kano, and it's just along Gidan Malamai, that is behind Skyline University. And our phone numbers, if they search in our handles, they can see our phone numbers. And we are open Monday to Friday. Yes. Thank you very
Thank
much for the opportunity given.
you. Thank you very much, Your Worship. We are truly grateful. So, wow, that was very educating and eye-opening, actually. But as we come to the end of this session, I would like to summarize some key takeaways that stood out for me particularly. I think we were able to truly see the safeguards that are provided by the Kano State ACJL stand out during the conversation. We see rights like the prohibition of arrest in lieu, against double jeopardy, that's trying somebody more than once for a particular offense, and so many other rights. We also get to see that women can actually stand as surety. This law allows for that, as long as, of course, you do not, there are no limitations as was provided by the law. Also, on the awareness aspect, we're able to see how far awareness goes, and how it is able to change the legal landscape generally. We can see that when people know about the law, they also support those judicial justice actors that have been put in place to protect them. And also, it will help bridge the access in justice, particularly amongst members of marginalized communities. We've learned so much about the provisions of the Kano ACJL and the Justice for All project itself and its deliverables, and hopefully the outcome we intend to get from this project. I would like to thank our speakers, Your Worship, Salma Ahmad Ambapa and Barrister Jamila Inua Saad, for sharing their valuable insights, and also thank them for their active participation. You can see the passion from the way they talk, how passionate they are about the work. Thank you all for listening, for your presence and your engagement during this conversation today. And I would like to point out that this is one of many sessions that we will be scheduling going forward. So you will have several programs like this, discussions like this, where we will look at the Kano State ACJL and shed more light, get insights on how to better implement this law. Thank you very much for joining us today, and
You're
have
welcome.
a
You're
Thank
most
you.
welcome.
rest of the day. Thank you.
Thank you. You're welcome.
Same to you too.